1866. A prostitute hired a carriage to make a display favorable to her purposes, which at the time were considered immoral, or in Latin, Contra, bonos, mores, which actually just basically means against good morals. The poor lady was just doing this to use the carriage as just a way of self-marketing and to bring more customers, but the lady then failed to pay for the hire of the carriage. So Pierce, the couch builder who hired the carriage to her, brought a claim asking for recovery of his money. But the court then rejected his claim on the ground that he was already aware of her intention of using the carriage to promote her immoral activities, holding that anyone who knowingly supplies something for an illegal or immoral purpose can't sue for its money. This reasoning can find its way back to this Latin maxim:
Ex turpi causa non order actio.
I just can't pronounce it, which basically means no claims arise from dishonourable cause, which means you can't just hire an assassin and sue him for maybe not carrying the mission or something. The same maxim was actually expressed in the Holman versus Johnson case 1775, where the court stated that no court will lend its aid to a man who founds his cause of action upon an immoral or an illegal act. This same principle is exactly what makes most of the illegal contracts unenforceable, because the court basically can't help someone to just breach the law or something. Was this contract between the lady and the couch builder a void contract or unenforceable contract, and what is actually the difference between them? Well, this is the tricky part. Cases like this actually force us to ask, what exactly happens to a contract when the law says it's defective? And what would be the position of a third party who acquires in good faith the title from a void contract or a defective contract? Voidness, voidability, and unenforceability, they are just legal consequences for what is called vitiating factors, and we will just address them later. But what does it actually mean when we say a contract is void? The word void or null means something that has no legal effect at all. It is said that a void contract is one which is written in invisible ink. It was never there in the eyes of the law. It is a contract that has no legal force from the moment of its creation ab initio, which basically means from the beginning, but in Latin. For example, the basic position is that such a contract is simply one which the law holds to be no contract at all, a nullity from the beginning. The parties would be in the same position as they would have had the contract never been made. No property would pass under such a contract. A third party who purchased goods which had been the subject of a void contract would acquire no title at all to the goods and have to deliver them up to the true owner. Unless, of course, the law says otherwise to protect the third party, the innocent third party. However, a contract might be void only against specific third parties. For example, under the Companies Act 2006, failure to comply with the statutory requirements for registering a company charge, and we can just address what a company charge means later. So this failure can actually render that charge void against only certain people. In practice, this means those parties can deal with the company's assets as if the charge never existed. Here, the contract is void only against those people. On the other hand, a voidable contract is like one written in pencil. One party has the option to rub it out if they choose to, within a reasonable time, of course. It is a contract that is valid from the beginning, valid ab initio, but for some reason, one party can set it aside. Voidable contracts may arise through, for example, misrepresentation, some instance of mistake, non-disclosure, and duress. Third party in a voidable contract. Actually, in a voidable contract that has not been avoided at the time of the sale, a third party can actually still acquire good title to the goods. But if that third party qualifies as equity's darling, this actually means he has to be bona fide purchaser for value without notice. And bona fide, back to Latin again, it just basically means they must act in good faith. This third party must act in good faith. So bona fide means good faith. For value, they must give consideration, not receiving the goods as a gift or something. Without notice, they must have no actual knowledge and not even constructive knowledge. Basically means like they don't even have the obligation to have known of the defect in the contract. And this is stated in the section 23 of the Sales of Goods Act 1979 in the English law. When the seller of goods has a voidable title to them, but his title has not been avoided at the time of the sale, the buyer acquires a good title to the goods, provided he buys them in good faith without notice of the seller's defect of title. The reason behind the difference between a void and a voidable contract can be actually explained by an interesting theoretical distinction. This distinction differentiates between the absence of consent and the impairment of consent. The distinction is not actually limited to distinguishing between voluntary and involuntary actions, because impaired consent itself is in fact a voluntary action. On the other hand, a void contract, as a general rule, is based on a complete absence of consent. It is therefore involuntary and cannot have any legal effect. Unenforceable contract is one which is good in substance, but because of some technical defect, one or both parties cannot sue on it. So the contract here actually exists, but one or both parties cannot seek a legal remedy or sue the other on the ground of this contract. The difference between a void contract and an enforceable contract, well, a void contract is necessarily unenforceable. It is a contract that has no legal effect. It is a contract that is bad both in substance and in procedure, and a third party to such a contract cannot acquire any title. On the other hand, an enforceable contract, as we just mentioned, it is an existing contract. It exists already. So the contract is not necessarily void, and a third party to such a contract can get a good title from it. This video is just a start for some interesting and light legal videos. If you like it, please give it a rating and subscribe for more.